the resolution of this estate move forward.
Okay, so I think I understand that. So if I decided to appoint your client as the sole estate trustee, removing Mr. Melville as being responsible, then all of the details need not be addressed at that juncture. Only if there was an alternative type of remedy formulated where Mr. Melville continued to be legally responsible, would I need to delve into all of the particulars that would be needed to assist the estate moving forward.
That is correct.
Okay. And Mr. Melville makes a submission that he's incurred some expense with regard to dealing with the personal property in the house, that it was not chosen by him or Nicole, and he suggests that that would be simply a claim against the estate by him to come at a later date with supporting evidence. What's your comment on whether that process could take place?
I mean, I suppose without having seen any of the documentation, I'm limited in the position we would take on his submission of a claim. Certainly, it would be my view that junk removal service is something commonly taken on by an estate by paying parties, and I've been involved in many where even in large houses filled with things, it's taken several days or a couple of days to pay someone. So, I mean, without seeing what it is that he says he has spent and what it was he did, it's difficult for me to provide a response. Certainly, any determination you make today wouldn't necessarily close his ability to raise the issue. And Nicole, as either sole estate trustee or a joint estate trustee, would have to determine, once she was able to review what it was he's asking for, what her position is on that. I disagree that Mr. Richard, who I believe Mr. Melville was referring to earlier when he talked about the advice he had received from Mr. Kelly on how to submit estate expenses, I disagree that Mr. Richard can make that determination. I think that either the estate trustees, estate trustee alone needs to agree that those amounts be paid, or there would have to be some sort of claim commenced by Mr. Melville to seek that amount. It's not something that Mr. Richard has any ability nor likely any desire to make a kind of a final determination in terms of who's entitled to what.
Right. And with regard to that point, in my current understanding of the way the minutes of settlement were drafted with regard to my jurisdiction, would that not, if that was unable to be resolved, that would fall back on me?
That would be my understanding, yes. That certainly the minutes of settlement would require Neil would have to bring a proceeding in front of you effectively if there cannot be agreement reached on any amounts that either Nicole or Neil would be entitled to. I do believe the minutes of settlement already address that Nicole is to be reimbursed for the out-of-pocket expenses she has continued to pay to cover at the property, which included at the time of the mediation and continues to include the mortgage amount as well as the insurance amount.
Right, and I'm just following up on your submissions with regard to the claims made, the specifics of the claims made against Neil Melville are necessarily have to wait until such time as they become coate or perfected, because as each day goes by in your client's position, further damages are incurred.
Correct.
And so the only reason I bring that up is as unfortunate as this may be, it sounds like we may have to come back. That it seems to me that your client should, once the damages are able to, you could do a damages brief and send it to Mr. Melville, who may or may not agree with it. I'm suspecting the latter. And have to come back. So we sort of have to come back anyway.
I think it's difficult to do it any other way without knowing what your decision will be following today, as well as the natural kind of consequence of that. The property, in our view, should be sold. And so once the property is sold and the net proceeds of sale are being held, the dates will be clearer in terms of how long Mr. Maven resided at the property, what steps may in the meantime be necessary to effect any order you may make today. Incurring continued costs seems likely to me based on what has happened to date. So yes, certainly I'm of the view that the ultimate determination of what Mr. Maven may owe to the estate and or to Miss Lapierre cannot be determined until we know the outcome of the property and the date that it is transferred to a third party or otherwise transferred.
Right, and similarly, it seems to me that your client wouldn't be able to calculate her claim, if any, with regard to damages as a consequence of the breach of the minutes of settlement. In other words, if the house sells for more money than Mr. Maven agreed to pay, then your client wouldn't have any damages. But if it sells for less, then your client may wish to claim damages against Mr. Maven for the difference, but that wouldn't be known until the house was sold.
That's correct.
Yeah, okay. All right, unless you've got anything further you need me to hear, I'm just going to ask if do you have any other reply submissions?
The only other reply I would make comment on very briefly is the insurance damage, I will call it, issue. I think Mr. Maven raising various things that have gone wrong at the house that he appears to say he has been required to fix or that have been required to be addressed only furthers the need for this property to not continue as a liability, frankly, of the estate. It's clear that repair of the property is an issue, and as is the case in the decision that I provided earlier this morning, the Phillips-Brown matter, where that's starting to happen, it's even more of an urgent reason for the property to be vacated and sold so that the estate does not continue to incur damages or potential damages of that nature.
Okay. Now, Mr. Maven, I'm going to propose a 15-minute break now. Did you need any time longer than that to review the decision in the Filippini case and to comment on either my questions or comments to Ms. Phillips-Brown? Not, and so that basically anything new that's